Welcome to Elevating Lives. I'm Charles Evdos, Executive Director of Rise Life Services. The goal of our show is really to help and educate individuals who may have autism, special needs, disabilities, mental health issues. Wherever we can help, we're there to support you. At the end of the show, you'll see a 1-855 Rise Life, which is our helpline. If we can help you, we will provide services within our organization. And if we can't help you, we will direct you into the right direction. Today, our show basically is featuring special needs trust and estate planning and how that can help you and your child or individuals. Rise Life Services has 32 sites throughout Suffolk County. We have two food pantries, one in the Hampton Bays and one in Riverhead. And we also have a food truck that also delivers food to individuals who can't come to our food pantries. The need for food pantries has grown over 300% since this pandemic started. And we see the need. We don't get funding for it. We count on donations. We're very happy that Island Harvest, Long Island Cares, ShopRite, Panera Bread, and many others support this program and make it succeed. And we are going to be expanding it to other areas throughout Suffolk County. And our goal is to help those that really need the service. Today, my guest is Donna Stefans. She's an attorney. She's going to talk about estate planning, wills. And Donna, welcome to the show. Tell us a little bit about yourself.
Charles, thank you for having me today.
You're welcome to have you. Tell me a little bit about yourself, your firm, and what you do.
Okay, so I am Donna Stefans. I am an attorney at Stefans Law Group. I created the firm. And we really focus on estate planning, special needs planning, and elder law as a total focus. My background is also part of another company within our organization called Wealth Advisory Associates, where I am a licensed financial advisor, as well as an accountant with our third component, the tax department, Summit Tax Advisors. So where we put together the legal, the financial, and the tax implications all together. And the law practice is really focused on the financial planning end of the law.
That's great. It's great to have three different categories to work with. It's unusual that happens in this type of business. Tell me a little bit. What I've found and read that 70% of the attorneys out there don't have wills. I mean, is that the case? I mean, is that true? I mean,
it's a staggering and frightening number. I mean, right? The shoemaker's shoes. Right. Everybody's very busy. And this is not exactly the hottest topic that people want to talk about or the most fun. However, it is something that keeps people up at night. But it's avoidance, and it's the fear factor. And I will tell you, in the special needs community, it's even worse. In the special needs community, it's about 9 out of 10 people have not planned.
Really?
And,
wow.
And in the country, maybe attorneys are even worse than most, but about 65% of people in the United States do not have a last will and testament.
Wow, that's terrible.
Are not saying
right.
The most important thing for their future family and legacy is who gets what, how I get it, and how are we going to provide for our families when we're gone.
No, exactly correct. And it's sad because nobody feels like they're going to die. And they wait to the last minute, and especially with the special needs trust and various other aspects of estate planning. What I'm finding is with managed care coming through the pipeline, that the state really wants individuals, once they hit 21, to stay at home. And you really have to structure your, whether it's Medicaid, Medicare, your estate, whatever, to make sure that you maximize the funds you're going to receive. Tell us a little bit about that. How can your firm help us with that?
Well, I think that the first thing to really come to terms with is an understanding. As a parent, and specifically as a parent with a child with special needs at any age, you are that child's advocate. And nobody's going to take care of your child better than you.
Right.
So if you're gone, who could you possibly put in charge of their best interests and do things as well as you could for your child? I mean, I think that concept is daunting and overwhelming. And the reality of the matter is the thing that you need to do is start the process. I can honestly say, sitting down and taking an inventory of what you have, and then having an understanding of your child as to, if I'm not here, ask yourself the question, what would I want for them? Where would I want them to live? What would I want to provide for their lifetime care and their quality of life? Well, in order to do that, to take an inventory of what you have and see what the benefits they can receive and are able to receive, and then how you build a plan so that if you're gone, the right amount of money can get to them for their needs, the right trustees that you trust to handle their money, guardians to put in place so that they can physically take care of them and have the legal authority with the court to be able to handle everything for them. These are the things we want to lock down. Put it in writing. So when we meet with a client, we start by what we call the estate planning questionnaire, right? Where we ask you to give us family history. Where are the accounts? Who are the beneficiaries? Do you have life insurance? How are we providing for your family when you're gone? But I really think the focus has to be caring for ourselves to be able to care for our loved ones so that we have a secure life to be able to give them a secure life. Because if we can't take care of ourselves, if something happens to us and we get hurt or we become incapacitated, or God forbid, down the line, things that we think about in elder law, dementia, that's a whole different ballpark we're playing in. But if you don't protect yourself and you don't protect your assets and we don't do special mechanisms to provide for your child with special needs, the whole plan will fall apart. In the end, there may be no money. In the end, you might need a guardian. So we always talk about lifetime planning and the afterlife time planning.
So it sounds like an ongoing process. It's not like, okay, I did my trust or estate planning and we're done. That's it. You have to, I would assume, every couple of years, work on your estate and so forth. Am I correct in that statement?
So we say about every 3 to 5 years, you usually have some kind of life change. So it's always good to check in every 3 to 5 years to check in on, one, what I call your cast of characters. Are the people that you have out there the right people in charge today and now 5 years from now, right? Are they even living here anymore? Was there a falling out? Do you think that that person's really capable of doing this after seeing what they've done over the last 5 years? That might be the same or change. And so it's always good to check in on things, especially if there's divorces or
True.
people die. But we start with the basics. We start with what I call the Fabulous Four. So the Fabulous Four are your...
Sounds like the Beatles.
Yes, yes. So the advance directives being appointing somebody for yourself to handle financial and medical affairs if you cannot do so yourself. Again, take care of you first. It's kind of like the airplane. You want to put your oxygen mask on before you put it on your child. Otherwise, you won't be able to do either.
Right.
So power of attorney is the first, I think the most important for financial affairs. Legally appointing somebody to do that for you. And healthcare proxy, medical decisions, appointing somebody to handle your medical decisions if you cannot do so yourself. And then, of course, the end-of-life decision-making, living will. So those are all the life care and how you can accomplish them for yourself to protect you and your family. And then sometimes, depending on the person with special needs, they may have mental capacity to do these documents themselves when they're over 18. And if so, we highly encourage them to do that for themselves. And then you can, as a parent, continue to handle their medical and financial in any way that you normally would as a parent. So I think that's the beginning. And then, of course, we go to the last will and testament. Now, you mentioned it. I think you're right. 70% of attorneys and 9 out of 10 families don't have a will. But the truth be told, everybody's got a will. They just might not like the way it reads.
Right.
Because if you didn't write a will, New York State has written one for you.
Unfortunately, right.
Well, there's got to be some order,
Right.
right? There's got to be some structure and order to delineate who gets what and how they get it if you were silent. So the court and the state have written that order. So you might not like that. So if you want to do it yourself and take charge of your life and put the assets in the right place and the right people in charge, you do a will.
Right, and there's tax implications if you don't do it. I mean, New York State could take, what, 65%, I believe is the number, of your estate?
In
and
estate taxes,
yeah.
Estate tax is an ugly conversation.
Unfortunately, yeah.
Yes.
And you really don't want to work all your life and build up your estate and have to give 65% to the government. I mean, it's crazy. It really is. But if you structure it correctly, you could definitely reduce those taxes and maybe not pay any tax.
Right. Absolutely. Absolutely. In New York, the number's today $6 million that we have to think about, if you're even close to that. And people don't consider, well, I have a house and I have life insurance. Well, you could be close to the $6 million right there, and thinking that you're just the person next door that doesn't need a will because you're not ultra rich.
So are you saying that once you go over $6 million, you shouldn't go over $6 million, you should keep it under $6 million?
You got to keep it under $6 million in New York. Otherwise, you go off what we call the estate tax cliff.
Interesting.
It's a bad thing. But either which way, when we talk about special needs planning, we're looking at some extra special devices that we need to do. Because if we don't do a plan, what we do know is that a person with special needs has the ability to get government benefits. So if you're the advocate and you've worked really hard to get your family member Medicaid, right, to cover custodial care needs at home, maybe some day hab programs, different things for their daily living, and medical insurance, and then we can get SSI, which is a Social Security income program, which is meant for people who were disabled before they were 22, and they have a parent with a working record, just like for regular Social Security. You know, a person in a community with special needs can have great benefits to support themselves in life, for housing, you know, clothes, the basics, and you can build in yourself as the parent the extras, the quality of life,
Right.
you know, the niceties that give them, you know, the smiles on their face. But if you don't leave your assets to them in the right way, you'll be gone, and they get kicked off their government benefits, and they probably aren't going to be capable of doing this for themselves to get back on benefits, even if they knew how, and you have a big mess. So you work so hard to build up everything for them, and then if you don't plan the next step, all your hard work can be gone. The money that you want to leave them can be just flushed down the drain, and then they lose all their benefits and they're stuck. And the people you appoint around them may not know what to do about it.
Right. And it is very complicated, no question. I mean, many times I hear a child has cerebral palsy or some type of disability. They get a settlement, and it's not structured correctly. And what ends up happening, like you described, the government uses that up first, and then once that's used up, then you get the benefits of SSI, Medicaid, Medicare, and so forth. So let's say my child has cerebral palsy at birth, and we settle for $2-3 million with the doctor. How do we structure that to protect the child and the family, to make sure that my son or daughter are taken care of when they're over 21?
Yes, it's a very unfortunate situation. However, the government doesn't want to see people penniless, right? And especially in these situations, they want to have supports in place for a person. So if they have the ability to receive money, the government wants to support a person with this kind of special need and others, and also give them some type of individual supports like the lawsuit money. So there's two types of very important documents we can do. They are supplemental or special needs trusts. Okay, they are meant to supplement, but not take away the government benefits that they would be entitled to as a disabled individual. So what that means is there's two types, right? There's what we call a first party special needs trust and a third party
What happened to
special
the second
needs
party?
trust. There's no second party. Good question. I'm thought about that. Um, so, in the case where a person receives money, so this person in your case is receiving money from a lawsuit, it's in their hands. So, the government says you can set up a first party, me, myself, special needs trust for myself. Of course, I can't do
That's
it
for the child,
myself.
for the
Right, I can't
okay.
do it myself. I'm a child.
Right,
You know.
okay.
So you have a parent, guardian, or a court set up this first party trust. And it says this money that's coming to me can benefit me for my lifetime. However, when I pass away, whatever's left in that trust goes back to the government to pay back for the services that you received in fairness. So the government's giving you the ability to have the quality of life issues, to, you know, I have one client where her favorite thing to do is to go to the mall and spend $75 on things in a couple of the stores. That makes her smile.
Right.
It could pay for the special computer, certain adaptive equipments that Medicaid doesn't cover. It could pay for a vacation. It pays for the quality of life and the smiles that they deserve, everybody deserves, and in a way that they're supported on all levels. But again, the problem is in those situations are, at the end, the family doesn't get the money. The parents that struggled their lives with this, all of the advocacy and situations, they don't get the money either. It goes back to the government. So that's the structure. And the other thing is you have to account to the court on a yearly basis
Wow, I didn't realize that.
on how that money is spent. Well, it technically is government money.
Right,
So they want to know how you're spending it, appropriately spending it,
right.
and not spending too much. So your hands are tied on how you can spend that money. So as a guardian, you have a big responsibility, and you have to be bonded. So it's quite the headache to do a first-party trust.
Sounds complicated, no question.
Right, but guess what?
You need to do
If you don't do your own planning, you know, for lawsuits aside, I'm a parent and I want to provide for my child with special needs when I pass away. If they could get government benefits or have government benefits, if I give them money, retirement account, regular account, life insurance, anything, they're going to get bumped off those benefits. So now we bump off the benefits. Then we have to go to the court to do one of those first party special needs trusts, right?
Okay.
And then, again, that money is there for them. So that's a good thing. But at the end of the day, it doesn't go to my other children. It doesn't go to family members. It goes to the government. So it's good and it's bad. You can do so much better planning than that, right? That's what we call the third-party trust or a supplemental needs trust,
Okay.
done by the parent. Could be done by anybody, just not the person with special needs. So it's, again, meant to supplement but not take away government benefits. And so if you can picture the estate plan, it says, I would like to leave. I have 2 children, right? I'm leaving 50% to my son, Johnny, and he'll get the money when he's 30 because at 15 he can't handle half my assets. So he gets a trust, but it's really a trust for minors, right? It's going to have a trustee, somebody who trusts to put in charge of spending for them and their lifetime care and quality of life till they're, 30. But then for my daughter, Susie, who has special needs, I'm going to leave her money in a supplemental needs trust, meant to supplement but not take away her government benefits for her quality of life. And I get to pick the trustee, and I get to control what goes in there. And then at the end of the day, I get to say who gets it when Susie's gone.
So that can go to another individual, a charity, or whatever.
It can go to a charity,
Right.
and that's often the case. So the different charitable organizations that help the person with their quality of life and lifetime care. For example, like Rise Life Services, different places like yours. Often that is the case, that you've provided such a wonderful benefit for this person that people like to give back to that. But also other family members, you can leave it to, and nobody has a say in it but you as the parent. So the point is, By you taking control of the situation, you will create the plan for your family's lifetime security. And this is what makes sense.
Right.
So you could do a supplemental needs trust in a last will and testament, or you could do it in a revocable trust, or you could do what we call a standalone third-party trust, where it just sits over here, and you're the trustee as a parent. You could put two people as trustee if you'd like, and backup, that you can put money in now. You could leave it until you're ready to fund it. So you could have a life insurance policy, and in special needs planning, we use life insurance often because we know that money will be there. We can't guarantee for the rest of our lives that our money will be there. Right? That's what elder law and that long-term asset protection planning comes in later.
Right.
I mean, we could fall on hard times. So life insurance can secure the funding of a third-party trust, right? So that money can be there. But also, family members, right? If we have grandma and grandpa that want to leave Susie money, it could go right to Susie's trust from their will. And then the grandparents don't have to recreate the wheel and redo all that stuff themselves. So one trust over here can come from so many different places, and people that really love Susie and want to provide for her. It's one of the biggest mistakes in special needs planning, that people disinherit the child with special needs.
Right. They don't know of all these trusts and steps they could take.
Right, if they get money,
Yeah.
forget it. They're going to lose benefits, so we're not going to leave it to them.
Right.
And that is a complete myth.
Right.
So these trusts give that a person the ability to get the money that they need. So in fact, one of the saddest things that I see is that when a parent will put another child in charge of the child with special needs in a way that they may not be capable of doing it. In other words, they make the child, the adult child, hold all the money. They give all the money to one person. Or they say, here, earmark this money for Susie. Don't touch it, only leave it for Susie. And make sure Susie's okay for the rest of her life. That's a tremendous load.
Sure.
Right? And not only that, wait a minute. What if Johnny falls on hard times? What if Johnny lost his job? What if Johnny ran up his credit card bills? You know what? Let me just borrow Susie's money. I'll pay it back when I get a job. You know what? She won't even know. Or wait, subject to divorce. If it's in his name, it's subject to equitable distribution in a divorce. Susie's money could be gone. There's too much liability.
Wow.
Too much liability. When you simply, if you sit down and take the time to do the planning, it can be completely done. And I will tell you, the hardest thing to do is to make the appointment. That's it, the first appointment.
Wow.
Because you know what you want, you just need it laid out. And maybe you don't, and maybe the attorney can give you the guidance to get you down the path. But then, once you're on the path, it's done, and then we can sleep at night knowing that our family's taken care of.
I think that's key when you say make the appointment. It's because it sounds intimidating. It sounds scary. Oh my God, what should I do? But you would guide them. Your firm would guide them through this process, which is great.
Absolutely. We start with the estate planning questionnaire. Right? You sit down, figure out exactly what everything looks like, and I will tell you that exercise alone starts the process, because I know I have life insurance. Where did I put it? Wait, who's the beneficiary? Oh my God, it's only my husband and then nothing. Wait, what? I thought I did something with that. And retirement accounts. Who's the beneficiary? Can't leave little kids the beneficiary of $1 million IRA.
Right.
Just riddled with problems. So if you sit down and you say, what does it look like? That's the start. Then when you bring that to a special needs attorney, and I really recommend working with an attorney that focuses in the area of special needs planning. It's very technical. It's not your basic will. It's not your basic document, and you better have a good one up to snuff with the proper government language, with the proper government codes. I've seen many a special needs trust blow up because there's provisions in there that shouldn't be there that went out of law a long time ago. So you have to go with somebody that knows what they're doing in a specialty. You know, you don't go to the cardiologist for a brain issue. Right? You don't. So everybody's got a specialty, and I think in this field it's super important to do that. But the way we look at the situation, we lay out your financial situation, we create the legal plan, and then we layer on the financial plan to that legal plan. Because if you can make a great legal plan, but if your money doesn't go to the plan, it's got to go through the maze properly, otherwise it doesn't work at all. No. So you cannot look at legal in a bubble. You cannot look at financial in a bubble. But I'm going to give you one of the best things that in special needs planning that has happened recently that many people don't know about. And it's called the Secure Act. Now, I don't know what you might know about, Charles, about the Secure Act.
Please tell us about it. It's important.
I would love to. It's really important. And it's good and it's bad. The Secure Act began in January 2020. We were all very busy with the unfortunate COVID situation to really see what that all meant at the time, but it came into play January 2020, and now you're starting to see about it. You can read about it if you look it up online, but it's securing a retirement future. So what it means, there's a couple things for the individual, increasing the age that you have to take out the required minimum distributions as a retirement plan owner, whether it be 401k, 403b, any of those IRA. But unfortunately, when your next generation has to receive those IRAs as a beneficiary, they must liquidate that entire retirement account within 10 years' time. That's not a good thing. For your children without special needs, they could get decimated in income taxes. If you have $1 million IRA and Johnny gets $500,000, he has to take that out over 10 years. I mean, that hurts big time on a tax return, especially if you're 80 and your kids are typically in their 50s, their highest earning years, right, and now they're forced to do this.
Donna, it sounds like a lot. Tell me about your...
Wait, but the last part, the good part about special needs, the best rule was for special needs, because they said if you leave a person that is permanently disabled, your IRA, and we fund it into a supplemental needs trust, they don't have to do that. Right. They could take the money over their lifetime. It is one of the best benefits.
It's for somebody with a disability, right?
So focusing on those IRAs is a huge part of the new plan. Donna,
if people want to contact you, where can they call you, or your email address?
So Stefans Law Group is www.stefanslawgroup.com, and just like my name, Stefans, and our phone number is 516-692-2744, and we have offices in Nassau County and Suffolk County.
That's great. Donna, thank you for being on the show, and I want to thank our audience for hopefully the show presents some creative ideas. It's very complicated, I understand that, but we're here to help, and if you need me to help you with anything on a child having a disability, or Donna having her experience with the estate planning and the special needs trust and so forth, we're here to help. Thank you again for watching the show. Have a great day, everybody.